Hello, my name is Tim Callgreen, Director of Civic Education at the Indiana Bar Foundation and Indiana's Mock Trial State Coordinator. The Indiana Bar Foundation would like to thank several people for their assistance in creating this video. Thank you to teacher Janice Houghton and the students of Heritage Christian High School. Thanks to Judge James Sweeney at the U.S. District Court for the Southern District of Indiana for judging today and the use of his courtroom. And thank you to the National High School Mock Trial Championship for the funding and support of this production. What you're about to watch is a performance by high school students arguing a fictional court case in a mock trial. The goal is for you to see a full-length example and have better understanding of what a mock trial is as you bring mock trial to your school. This is the case of Jordan Patel versus Cameron Miller. It is a civil case where one private party is suing another individual. The case is based on Indiana's dram shop law. This allows a person injured in an alcohol-related accident to file a civil suit for damages against the person who caused the accident, as well as the individual or establishment that furnished alcohol to the intoxicated person. You will see 3 witnesses on each side of the case. For the plaintiff, you'll hear from Jordan Patel, the plaintiff, Bobby Brennan, a friend of the plaintiff and an eyewitness, and Dr. Alex Diaz, an emergency room doctor. For the defense, you will hear from Cameron Miller, the defendant, Morgan DeLuca, friend of the defendant and an eyewitness, as well as Dr. Joe Strickland, a medical doctor reviewing the case. Jordan Patel, Bobby Brennan, and Cameron Miller were all volleyball teammates at Harmony State University in New Harmony, Indiana. But just because they're teammates doesn't mean they're the best of friends. A rift has formed between Jordan and Cameron, and it seemed to permeate outside the volleyball court. As the school year ends, Cameron's friend, Morgan DeLuca, convinces Cameron to hold a party. The party was supposed to be a chance to host a decent college party, which was a goal of Cameron's before the college career closes. But as college parties go, this one became overrun with more people than Cameron wanted at the house. Jordan and Bobby show up at the party, and with some uncertainty if they were actually invited. While at the party, alcohol was consumed and an angry confrontation ensued. Jordan was injured and taken to the hospital. Dr. Alex Diaz eventually found a neck and vertebrae injury and found the injury to be severe enough to limit Jordan's playing time as an athlete. Dr. Joe Strickland, another medical expert, found that while Jordan was injured, the injuries he had healed and are not a long-term issue. Jordan is now suing Cameron, claiming Cameron to be in violation of Indiana's dram shop law, furnishing alcohol in a manner that violates the law, and should have foreseen that an injury could have, and actually was, caused by this action. So now, let's call to order the case of Jordan Patel versus Cameron Miller.
All rise. The United States District Court for the Southern District of Indiana is now in session. The Honorable James R. Sweeney II presiding.
Good morning. Please be seated. Well, welcome to the Indiana mock trial high school competition. I'm going to go over some rules here this morning that we will abide by, and then we will open the case and proceed with it. While I do these reminders, if everybody would look around, make sure that there's nobody in the courtroom that shouldn't be here. It should be members of the teams, coaches, parents, those kinds of things. And just let me know if you see somebody who shouldn't be here. Nobody should be recording the trial. Now, this proceeding today will be in person. Sometimes we will do these by remotely, by Zoom. In that case, there will be some instructions whether or not to mute or unmute your cameras, but for the purposes of this, we're in person. A reminder to those in the audience not to say anything that might identify you with either team, and I think that's all I need to say. So we are on the record now in the matter of Jordan Patel versus Cameron Miller. And I'd like for the prosecution to please introduce your team for the record.
Yes, Your Honor. Good morning. My name is Haley Bach. I'm an attorney for the plaintiff. Would you like us to address pretrial matters at this time or introduce ourselves?
Why don't you introduce yourself right now, Ms. Bach?
All right, my co-counsels and our witnesses will introduce themselves.
Okay.
Good morning, Your Honor. My name is Kenna Nezro, and I will be directing Bobby Brennan in crossing Morgan DeLuca.
Good morning, Your Honor. My name is Lucy Baker. I will be directing Dr. Alex Diaz and crossing Dr. Joe Strickland. I will also be doing closing statement as well.
Okay.
Good morning, Your Honor. My name is Michael Simone Favors, and I will be portraying Jordan Patel.
Okay.
I'm Caroline Myers, and I'll be portraying Bobby Brennan.
All right.
Good morning, Your Honor. My name is Alex Raber, and today I will be portraying Alex Diaz.
All right. Thank you. All right, Ms. Bach, if you want to proceed with any preliminary matters.
Thank you, Your Honor. We would like permission to move about the well freely, if that is okay with you.
Okay. You're saying during questioning and opening statements? Or
Yes,
what?
Your Honor.
Okay. Why don't we start with, I'll give you leave of the well for opening statements. After that, you can ask permission to approach the witness or whatever if you need to, all right?
And would you like us to, after exhibits have been entered into evidence and posted to the jury, place them on your bench, or where would you like them to be?
I've got copies of all the exhibits. You've provided me with an exhibit binder, so thank you.
All right, and we would also like this court to take judicial notice that all stipulations have been entered into evidence.
Stipulations are entered.
And would you like a copy of the stipulations?
Sure. Thank you.
And we also ask that any remaining time for the closing statement be left for rebuttal.
Okay.
No further matters from the plaintiff.
All right. So, and on behalf of the defense, if you'd introduce your team and.
Morning, Your Honor. My name is
Morning.
Luke Tiernan. I'll be directing Cameron Miller and crossing Dr. Alex Diaz, and my co-counsel will introduce themselves.
All right.
Good morning, Your Honor. My name is Maya Favors. I'm an attorney for the defense today. I will be directing Dr. Joe Strickland, crossing Jordan Patel, as well as giving the closing argument.
Okay.
Good afternoon, Your Honor. My name is Zachary Barnes. I'm an attorney for the defense, and I will be directing Morgan DeLuca and crossing Bobby Brennan.
Okay.
Good morning, Your Honor. I'm Madeline Fulton, and I will be portraying Morgan DeLuca.
All right.
Good morning. My name is Brooke Miller, and I'll be portraying Cameron Miller.
Good morning.
Good morning. My name is Keegan Fick, and I will be portraying Dr. Joe Strickland.
All right. Thank you. Any preliminary matters for you, Mr. Tiernan?
Not at this time, Your Honor.
All right. How about, do we have a batting order for the prosecution or for the plaintiffs today? In other words, what's the order of your witnesses today?
Yes, we do, Your Honor. Our first witness will be Jordan Patel, next Bobby Brennan, and our last witness will be Alex Diaz.
Okay.
Would you like us to give our order for the defense as well?
Please.
Our first witness will be Cameron Miller. Our second witness for the defense will be Morgan DeLuca. And our last witness will be our expert witness, Dr. Joe Strickland.
All right. How about our timekeepers? Do we have timekeepers today?
We do not have timekeepers today, Your
All
Honor.
right. Well, let's pretend that we do. So I'll remind the timekeepers that they are keeping time for both teams and that they can hold up their numbers. And if that there are more than 15 seconds discrepancy, if there is more than a 15-second discrepancy between the timekeepers, then we'll figure that out. And of course, the timekeeper should notify the court when time has expired. And why don't we go ahead and Why don't we swear all the witnesses right now? So if the witnesses would stand, please, and raise your right hand. You promise that the testimony you're about to give will faithfully and truthfully conform to the facts and the rules of the mock trial competition? If so, say I do. All right, you may be seated. And on behalf of the plaintiff, opening statement, was that Ms. Bach? Will you do an opening statement? You may proceed with your opening statement. And I think you have, 5 minutes for your opening statement?
Yes,
So.
This case is about the alcohol. On May 2nd, 2020, Jordan Patel, a student at Harmony State University, had her whole future in front of her, including a promising volleyball career. But her promising future was taken away the moment she made the choice to walk into the defendant Cameron Miller's party that day. The defendant's party had alcohol, lots of alcohol. The alcohol was purchased by the defendant. The alcohol was located at the defendant's home. The defendant could have chosen to control their alcohol, but they did not. The alcohol was self-serve, free-flowing, and unmonitored, and this was a problem. This was a problem because once the defendant opened their home to guess to whom they would be serving alcohol, they assumed a legal duty under Indiana's dram shop law. Under this law, the defendant had a duty to cut off visibly intoxicated guests, to ensure that visibly intoxicated guests were not served more alcohol. But the defendant failed this duty. Because of the defendant's failure, the plaintiff, Jordan Patel, has filed a claim of negligence under Indiana's dram shop law, Indiana Code, section 7.1-5-10-15.5. As the plaintiff, we have the burden of proof. We will prove by a preponderance of the evidence, meaning more likely than not, that Cameron Miller violated the dram shop law. To do this, we will prove 3 elements. First, that Cameron Miller had a duty to not overserve alcohol at the party. Second, Cameron Miller breached that duty by first having actual knowledge that a guest was intoxicated, and then knowingly furnishing alcohol to a visibly intoxicated person. And then third, that this injury was the proximate cause of Ms. Patel's suffering, pain, medical bills, and damages arising from the loss of her volleyball career. We will demonstrate that upon arrival, Jordan was welcome to drink alcohol from a self-serve keg. Jordan is a college student. She likes a party. She enjoys drinking. She enjoys having a good time. The defendant observed Jordan in an intoxicated state. The defendant observed Jordan jumping on a bed, slipping, falling, crashing into a pile of Legos. Later, the defendant observed Jordan after getting into a physically violent altercation. The defendant did not act. But Jordan was not alone that night. She was accompanied by her friend Bobby Brennan, another student at Harmony State University. Bobby will describe a party that was laden with alcohol and out of control. Bobby was afraid that night. Afraid about an out-of-control party. Afraid for her friend Jordan Patel. Lastly, we will explain the extent to which Jordan has suffered from the injuries on May 2nd, 2020, through expert neurologist Dr. Alex Diaz, an expert in 20 years' experience in her field. This case is about the alcohol. Cameron Miller had a duty to cut off a visibly intoxicated Jordan Patel, but they did not do so. Because of their failure, Jordan Patel has suffered injuries resulting in the loss of her volleyball career, pain that she still feels to this day. At the end of the trial, my co-counsel, Lucy Baker, will come before you and ask that you find the defendant liable for their actions that day. Thank you.
All right, thank you, Ms. Bach. Mr. Tiernan?
Yes, sir.
On behalf of the defendant.
Actions have consequences. We've all heard this sage advice at some point in our lives. And this trial will reveal serious consequences of a series of bad decisions and actions of the plaintiff, Jordan Patel. Ms. Cameron Miller is being sued today because of the consequences of Jordan Patel's own actions, which occurred at and after attending a party at Ms. Miller's home. The plaintiff will have you believe that this trial is all about the alcohol by the defendant. However, this is not the case. This trial is the story of a quiet homebody who finally gave in to the persuasion of an old friend to host a college party. The party Cameron Miller intended to be limited to a small group grew over 100 people after her friend Morgan DeLuca made a number of social media posts about the gathering and even shouted out a general invite in a popular hangout in their college town. DeLuca's posts opened up the party to individuals that Cameron Miller certainly did not intend to invite, such as the plaintiff, Jordan Patel. While Ms. Miller and Patel were acquainted with each other from having been on the Harmony State co-ed volleyball team, they were certainly not friends. Ms. Miller has the privilege of living in a house off campus rather than in the dorms, and Mr. DeLuca and some other students view that as an opportunity to turn a gathering there into a wild party. While all of this is important to understanding the context of why we're here today, what is at issue today is that Patel's own irresponsible actions were the direct cause of his injuries and not the party hijacked by Morgan DeLuca. Today you will hear very different stories from 4 witnesses who were at this hijacked party. The plaintiff, Jordan Patel, a previous friend of Miller's, will tell her perception of how events from that evening led to an injury that they are trying to blame on Miss Miller. However, if you listen closely to the other 3 witnesses that were at the party, there is still conflicting evidence. Even the plaintiff's own witness and Jordan Patel's friend, Bobby Brennan, has a different version of where and how the supposed altercation Patel was involved in occurred. Both of the testimonies given by the defendant, Ms. Cameron Miller herself, and her friend Morgan DeLuca align with Brennan's testimony over anything else. The evidence will show the fact that none of these 3 witnesses ever saw the alleged altercation and can definitively say there was an altercation or attack at all. But perhaps even more important is what Ms. Patel will not tell us about her many actions and decisions that contributed to her injury. One of these decisions being that after Patel's claims there was an injury in an altercation, she refused to get help off the ground in the party and refused the offer of an ambulance, and chose to go back to their college dorm after the party instead of going straight to the hospital. Upon arriving at that dorm, Patel literally ran into Bobby Brennan, and that is when they experienced excruciating pain and decided to go to the ER. In addition to the witnesses who were at the party, you will also hear from 2 different medical experts who will both examine the plaintiff, and again, there will be conflicting evidence. There is one fact that all witnesses will agree upon. There was alcohol consumed at the party by many guests, and the legal question at issue today relates to whether Miss Miller had actual knowledge that particular guests were visibly intoxicated, and that Miss Miller continuing to serve intoxicated guests additional alcohol was the direct cause of Patel's claimed injuries, and ultimately Patel's injuries resulted in damages. As we proceed through this trial, it will become more and more obvious that the plaintiff, which has the burden of proof, will simply not be able to prove any of these crucial points. At the end of today's trial, my co-counsel, Maya Favors, will ask that you find Ms. Cameron Miller not liable for Jordan Patel's injury, which is simply a consequence of Ms. Patel's own actions. Thank you.
All right, thank you, Mr. Tiernan. Plaintiff, please call your first witness.
The plaintiff calls Jordan Patel to the stand.
All right, Ms. Patel. You may be seated there. You understand you're still under oath, and if you would push that button there, I think that microphone will come on. Okay, you may proceed.
Please state your name for the court.
My name is Jordan Patel.
Jordan, I have some questions, just some background information that I'd like to lay. Now, you're currently a student, correct?
I am, yes.
Where do you attend college?
I'm currently attending New Harmony State University.
What are you studying at New Harmony?
I am a business major because I thought that'd be a good way for me to set up my life in a way that I would be successful.
And do you live on campus?
I do, yes.
What activities are you involved in with the school?
Well, other than my typical academic studies, I'm also on the volleyball team. In fact, I'm on a volleyball scholarship.
What were your plans post-graduation?
I was planning to first help my team make it to the championship and then go pro after I graduated.
Let's discuss your relationship with the defendant, Cameron Miller. How did you initially meet Cameron?
Well, our freshman year, Cameron, my best friend Bobby, and I were all on the volleyball team.
And how would you describe your relationship with Cameron now?
Well, we used to be close, seeing as we were teammates, but now we're not as close as we were.
I'd like to direct your attention to the day of May 2nd, 2020. Did you have plans?
I did, yes.
What were your plans?
Well, Bobby and I were going to go to Cameron's party.
Where was this party going to be held?
At Cameron's house.
And did you receive an invitation to the party?
Everyone did. Well, everyone who saw the invitation that was posted on Twitter.
You mentioned that you attended this party with your friend Bobby. Were you and Bobby together during the duration of the party?
Yes, Bobby and I arrived there together, but eventually we were separated.
And could you describe how the food and alcohol were set up at this party?
Yes, so after we got to the party, we entered the front door, and to the side there was a huge bar there. And behind the bar there was a keg set up, and we later found out that there's also a keg in the backyard.
And to your knowledge, were guests supposed to bring their own alcohol to this party?
No, there was nothing that alluded to that.
So when you arrived, when did you start drinking?
Pretty much as soon as we got there. I mean, we wanted to have fun, so Bobby and I started to drink.
Did you see the defendant upon arrival?
I saw Cameron eventually.
What was Cameron doing when you saw them?
Whizzing around, if you will, with a pitcher of beer, filling up everyone's drinks.
Let's move forward about an hour after you arrived. Could you tell us what the party atmosphere was like an hour into the party?
It started to get out of control. Everyone was drinking and serving themselves, and things started to get a little crazy.
Once this party was out of control, how did you react to that?
Well, I started to try and make my way out of the party.
And when you were about to leave, did you see the defendant, Cameron Miller?
I did see Cameron.
What was Cameron doing at this point?
Cameron was talking to a group of their friends, and they were all looking at me.
After you saw Cameron talking to a group of friends, what happened next?
Cameron's friends walked over to me and started pounding on my back.
How did your back react to this constant pounding?
Well, after they were consistently pounding on my back, I tried to get away, of course, and so I turned quickly to the side, and I heard a crack in my back, and I fell to the ground.
When you fell to the ground, were you able to get up and eventually leave the party in that situation?
Thankfully, I was.
And after you left, or as you were on your way out, did you hear anyone else say anything to you?
I did, yes.
What did you hear?
I heard what sounded like Cameron say something along the lines of, "What a little wimp, can't even take a congratulatory pat on the back for getting a offer to play pro."
Objection, Your Honor. Lack of foundation. May I be heard?
You may.
Pursuant to Rule 602, according to Ms. Patel's statement, a statement was made by Cameron Miller about a pat on the back, but Ms. Patel has just added words that were not included in her statement about a pat on the back regarding a volleyball scholarship.
Your Honor, if I may respond.
You may.
Ms. Patel heard Cameron Miller make the statement, which is party opponent, so it's not hearsay, that they couldn't take a congratulatory pat on the back. Now, if Ms. Favors would like to cross-examine Ms. Patel on whether or not that was the statement made, she could. However, this was this witness's perception, and so they do have knowledge on the statement that Cameron Miller made to them.
Ms. Favors?
Yes, Your Honor, I was not objecting to hearsay as opposing counsel was just referring. I was objecting to a lack of foundation. As Ms. Patel just said on the stand, she included words in her statement that were not there. She can say that Cameron Miller said something about a pat on the back, but to infer that it was regarding the volleyball scholarship is evidence that is not admissible, as it did not happen and is not included in her statement.
Okay, so as I understand the objection, it's that there's not a factual basis for it yet, is that it?
Yes, Your Honor, and I would move to strike the portion of her testimony that is not actually included in her statement.
All right, I'm going to overrule the objection. You can explore that on cross.
Thank you, Your
You
Honor.
may proceed.
Thank you, Your Honor. Jordan, let's discuss what happened after you suffered those injuries. Did you seek any medical help that evening?
Well, in the moment, I thought it was okay, so I wanted to go home. I called a Lyft, but when I got home, I felt a surge of pain that I hadn't felt before, and so my friend Bobby took me to the ER.
When you arrived at the ER, were any tests conducted to examine your pain?
Yes, they were.
And what did those tests reveal?
Eventually, I learned that I don't know the exact medical word, but I had developed, I think you could say, degenerative disc disease, and I also had suffered from whiplash.
Did the doctors prescribe you anything to help with the pain?
They prescribed me some painkillers and muscle relaxers.
You mentioned earlier that you were attending Harmony State University on a volleyball scholarship. How did this injury affect that scholarship?
Well, to this day, I can't lift my arm above my shoulder, and that, of course, is not good for volleyball. I can't play. I also had received an offer to play pro that I was, of course, going to accept after I graduated, but I can't do that anymore.
Thank you, Ms. Patel. Your Honor, I have no further questions at this time.
All right, thank you. Any cross-examination?
Yes, Your Honor. May I have a moment to turn my mic on?
Yeah, do you have a?
Yes, Your Honor.
Okay, sure.
Thank you.
Yeah.
May I proceed, Your Honor?
You may.
Good morning, Ms. Patel. I just have a few questions for you about the testimony you gave just a few minutes ago. First, I'd like to start with the direct examination you just had with Ms. Bach. Now, you mentioned that you believe you heard Cameron Miller make a comment as you left that night. Isn't that true?
Yes, I know I heard Cameron say something.
But you did not see Cameron yourself, correct?
Yeah, that's correct. I didn't see Cameron, no.
So, Ms. Patel, let's talk about your finances a bit. Now, you are attending Harmony State on a volleyball scholarship, isn't that true?
I am, yes.
And this scholarship pays for your schooling, doesn't it?
Yes.
Now, this is important to you because you claim that your parents don't give you what you don't earn, correct?
Well, yes, that's true, but that doesn't necessarily relate to my scholarship.
But that's not the question I asked you, Ms. Patel. I asked this is important because your parents don't give you what you don't earn, correct?
That's true, yes.
Now, as a volleyball scholarship, as a volleyball athlete, you had the opportunity to play professionally. Isn't that true?
Yes, I received a few offers.
And this offer would have helped you gain a lot of money, isn't that correct?
Yes, it would have.
Now, I want to explore what might have threatened that money you expected to get. Now, as an athlete at Harmony State, you are aware that athletes undergo random drug tests, correct?
Yes, that's true.
And at the ER on May 2nd, 2020, you did take a blood alcohol test, isn't that true?
Yes.
Now, you also have been diagnosed with degenerative disc disease, correct?
That's true.
Now, with the degenerative disc disease, you claim you have symptoms that affect your playing.
Yes, I do have symptoms that affect my playing.
And if you were to have this disease, it could significantly impact your volleyball scholarship. Isn't that true?
Can you rephrase the question?
With the degenerative disc disease, it could significantly impact the scholarship and the chances of you losing that, correct?
Yes, it does.
Now, Ms. Patel, you are aware that Cameron Miller has wealth. Isn't that true?
Well, yes, everyone knows that.
Given that you claim you were shocked that Cameron lived in a mini mansion off campus?
I'm not sure if I would describe it as shocked, but I did find that surprising.
You were surprised that Cameron lives in a mini mansion? Yes.
Yes.
Now, after not receiving, given the fact that you will not be receiving the money you expected to get, you've now decided to sue Cameron Miller. Isn't that true?
I'm not suing Cameron Miller because of. I'm sorry. I'm confused by your question.
After you are not receiving the money that you expected to get, as we discussed, you've now decided to sue Cameron Miller.
I'm suing Cameron Miller because of the injury that was caused at their party. Not necessarily because not only because I'm not getting the amount of money that I was going to get previously.
If I could redirect you to my question, after you not received the money you expected, you are now deciding to sue, not because, but after this happened, yes?
Yes.
So, Ms. Patel, let's talk about the injury you claim you sustained on May 2nd, 2020. Now, on the day of the party, you claim that somebody was beating your back, correct?
That's true. Someone was beating my back, yes.
And after this incident, you claim you were in extreme pain, yes?
I was in a lot of pain.
Now, after you were in this pain, you decided to leave the party, yes?
Yes, I did.
Now, as you were leaving the party, you went to the back door of the home, correct?
Yes.
But you couldn't get in the back door, could you?
That's true.
So you walked from the backyard around to the front yard of what you call a mini mansion, isn't that correct?
Yes, it was the only thing I could do.
All while being in this unbearable pain, yes?
I needed to get out of there. I did whatever I could do to get out of there.
That's a yes?
That's a yes.
Now, after you left this party, you walked a ways down the sidewalk even before calling a lift, isn't that correct?
That's true, yes.
And when you left this party, you didn't seek medical help, did you?
I did eventually.
You did not immediately go to the hospital,
I did not
yes?
immediately, that's true.
In fact, you went to your dorm, isn't that true?
I thought it was going to be okay.
That's
so
a yes.
I did go to my dorm, yes.
And when you arrived at the dorm, that's when you claimed that you, quote, ran into your friend, Bobby Brennan.
I did see Bobby, yes.
And it was at this point when you ran into Bobby Brennan that it felt as if every muscle was in your body was constricted.
Yes, it was in that moment that I started to feel that pain. I think it was because I finally felt safe.
Your Honor, I motion to strike the portion of the witness's testimony that contains speculation.
In which part would that be?
The part where she said she claimed her body had a certain reaction because she felt safe. She's not a doctor and she cannot make that type of evaluation about her body in that moment.
All right, any response?
Yes, Your Honor. This witness is testifying to what she felt in the moment. This is her perception. She's able to not speculate and testify as to how she felt.
May I respond, Your Honor?
You may.
Ms. Patel can testify to what her body was feeling in that moment. She cannot testify to why her body might have had a certain physical reaction, as she is not a certified professional and cannot give that type of testimony.
Your Honor, if I may respond.
Sure.
This witness is not testifying as if she were an expert medically diagnosing why her body was releasing tension at a certain point, but rather she's saying that she felt because she was more safe that maybe that's why the pain happened. Again, this is speculation, and the jury knows full well that Ms. Patel is not an expert.
All right, objections noted but overruled.
Yes, Your Honor. Now, Ms. Patel, as you just claimed, you felt that tension in your body in that moment. Isn't that correct?
I did, yes.
It was at that moment when you crashed into Bobby Brennan that you felt extreme pain in your neck and your arm.
I didn't crash into Bobby.
You ran into Bobby, yes?
I saw Bobby, yes.
You claim that you ran into Bobby Brennan, correct?
Meaning that I unexpectedly saw Bobby, not necessarily that I ran into Bobby.
It's your testimony today that you did not collide with Bobby Brennan?
Not in the sense that you're alluding to, no.
Ms. Patel, do you remember giving a statement before coming to court today?
Yes.
And was it true and accurate to your recollection?
It was.
You included everything that should be and pertinent to this trial today?
Yes.
Well, let the record reflect I am now retrieving your statement, Ms. Patel's statement, Your Honor.
Okay. Ms. Patel, can you try to hit that button again? It doesn't look like that's on.
It's on.
Okay, all right. All right.
Your Honor, may I approach the opposing counsel?
They should have a copy of it, right? You can approach the witness if you need to.
Yes, thank you, Your Honor.
Or do you need to? I don't know.
Yes, may I approach the witness, Your
You
Honor?
may. And I suppose we should have covered in opening or in preliminary matters the manner of making objections. Why don't we stand when you're going to make an objection so that that will get my attention. I can stop things. And then the same for the response. So please proceed.
Thank you, Your Honor. Ms. Patel, I'm now referring to your written statement, page 14. Read along with me lines 94 and 95 and 96. Now, we're going to start right here. I walked a little bit just to get away, then called for a lift to take me the rest of the way home to the dorm. I was in so much pain. As I got out of the car, I ran into Bobby, literally, as Bobby was also getting out of a car. All of a sudden, I have extreme sharp pain in my neck and down my arm. Did I read that correctly?
You did, yes.
Now, as you said in your statement, you ran into Bobby Brennan literally that night, yes?
Yes.
And when you ran into Bobby Brennan, that's when you felt that extreme pain that night, correct?
Yes, that's true.
Not at the party that night.
I was already feeling pain at the party.
But that's when you claim extreme sharp pain in your neck and arm.
Yes.
No further questions, Your Honor.
Thank you. Any redirect?
Yes, Your Honor.
Ms. Patel, opposing counsel asked you about losing your scholarship. Now, why can you no longer play volleyball? Why did you lose that scholarship?
Because of the injury that I got while I was at Cameron's party, I after months of physical therapy, I still can't lift my arm above my shoulder. I cannot play volleyball.
And was it your choice to abdicate this scholarship?
No, if I could still play, I would still play, but I just can't.
An opposing counsel questioned you on how you ran into Bobby. At the point which you collided with Bobby, were you running into him, or did Bobby catch you?
Bobby caught me. I don't know exactly what happened, but I fell and Bobby caught me in her arms.
No further questions, Your Honor.
All right, thank you. Any recross?
Yes, Your Honor. Now, Ms. Patel, as you just mentioned on cross-examination, you said that you can't play after months of physical therapy because your injury is still here, correct?
Yes.
Isn't it true you were prescribed medication for a doctor for that injury?
That's true, yes.
Medication that you did not take?
Well, you see, that medication wouldn't have necessarily caused...
Ms. Patel, if I could redirect you to my question, the medication that you were prescribed you did not take, yes or no?
That's true, I didn't take it.
No further questions, Your Honor.
All right, thank you, Ms. Favors. The plaintiff, please call your next witness, and you may step down, ma'am. Thank you for your testimony.
The plaintiff calls Bobby Brennan to the stand.
All right. You may proceed when you're ready.
Miss Brennan, can you please state your name for the court?
My name's Bobby Brennan.
And Miss Brennan, are you a student?
Yes, I go to college.
What college do you attend?
I attend Harmony State University.
And how are you paying for Harmony State?
I'm on a volleyball scholarship.
And what are your plans for after graduation?
Well, if time allows, I'd like to go into pro volleyball.
Now, I'd like to talk about your relationship with the plaintiff, Jordan Patel. Are you familiar with Jordan Patel?
Yeah, they're like my best friend.
How are you familiar with Jordan Patel?
Well, we've been friends since we were little kids.
Now, I'd like to talk about a particular party on May 2nd, 2020. But first, do you remember this party?
I do.
Who hosted the party?
Cameron Miller.
And are you familiar with the defendant, Cameron Miller?
Yeah, she played volleyball with me and Jordan a little back.
Did you receive an invitation for this party?
Yeah, I saw one on Twitter.
And why did you want to go to the party?
Well, I can't pass up a good party, and it was supposed to be very good.
So did this invitation ask for any alcohol?
No.
Did it ask for any money to bring?
No.
Did you expect people to be drinking at this party?
Yes.
Now, let's discuss the events that took place at the party. When you arrived at the party, did it look like a good turnout?
Yeah, there were like tons of people. It had to have been hundreds.
And can you describe the setup for the food and drink?
There were 2 kegs, one inside and one in the backyard, and some food inside.
Were there people congregating by these kegs?
Yes.
And can you describe the behavior of these people?
They were like drunken zombies.
So since these people were acting like drunken zombies, did you see anyone monitoring these kegs?
No, no one was watching how much everyone drank.
What about Cameron Miller? Did you see Cameron Miller at any point during this party?
I saw her later in the party.
And did the party ever seem to run out of beer?
No.
And was this a serve yourself type of party?
Yeah.
Now I'd like to talk about the altercation that took place during this party. But did you and Jordan attend this party together?
Yeah, but I kind of had to beg her to come with me.
Did you two stay together for the duration of the party?
Well, we were together for a little bit, and then I saw some other friends, and we ended up getting separated.
And did you see or hear this altercation?
Yeah, I heard a commotion during the party.
Thank you. Now I'd like to talk about the events that took place after the party. So you say you and Jordan didn't stick together for this party. Did you try and find Jordan?
Yeah, I ended up looking for a decent amount of time.
And since you were trying to find Jordan, did you try to ask anyone of Jordan's whereabouts?
Yeah, I actually ended up asking Cameron Miller.
Did Cameron Miller give you a response?
Not anything that was clear, a lot of non-answers.
So, since you weren't successful in your search, what did you do next?
Well, after looking for a long time, I decided that she had probably just gone back to the dorm, so I decided to go back to the dorm.
And when you got back to the dorm, did you find Jordan?
Yeah, somehow coincidentally, we got there at the exact same time.
And when you saw Jordan, did you notice anything unusual?
Well, I ran up to her and she collapsed into my arms.
And what did you do when she collapsed?
Well, she was obviously not well, so I had to take her to the hospital.
And on your way to the hospital, was there anything else you noticed about her?
Well, she was super non-responsive, completely not herself, and she kind of smelled like Cameron.
And what did Cameron smell like?
Alcohol. Reeked of it.
So with Jordan collapsing and the drunken zombies at the party, how did you feel about the situation?
Well, I feared for the safety of my friend and her well-being.
Thank you, Ms. Brennan. No further questions, Your Honor.
All right, thank you. Any cross-examination?
Yes, Your Honor. All right, Miss Brennan, I want to begin by seeing if you would know where Jordan got their alcohol that night. You know Jordan's drinking habits well, right?
Yeah, we've been friends for a while.
And you don't think that Jordan has the same hesitancy about drinking that you do, isn't that correct?
Yeah, but she's not as much of a lightweight as I am.
Now, you've gone to parties with Jordan in the past, right?
Yes.
And you've rarely seen Jordan without a drink in their hand.
Yeah, but everyone drinks at parties.
Jordan doesn't seem to be affected by alcohol.
Not as much as I am.
Now, in all the years that you've known Jordan and all the parties that you've gone to with Jordan, you've never seen Jordan drunk, right?
No, like very drunk.
But you've never seen Jordan to be intoxicated, isn't that correct?
Yes.
Right. Now, you don't know if Jordan had been drinking before this party, right?
No.
And given their tolerance, you might not be able to tell.
Yeah, I guess so.
You also don't know if Jordan brought any additional alcohol to the party, isn't that correct?
I don't know for sure.
Now, once you got to the party, you didn't stay with Jordan, isn't that right, Miss Brennan?
Yeah, eventually we got separated.
Right. So just to clarify, after you separated at this party, you didn't see Jordan again at all for the rest of the party?
No, I didn't.
All right. Now, because of this, you can't tell us how much alcohol Jordan was drinking, right?
No.
Now, as the party was beginning to end, Cameron was kicking people out of the party, right?
He was telling people to leave.
Right. You yourself got kicked out of this party, isn't that correct?
I don't know if I'd say that.
Yes or no, Miss Brennan, you got kicked out of this party, correct?
I don't remember that.
Okay. Now, I want to shift to the fight that happened in this party. But first, you would agree that Jordan and Cameron aren't on the best terms.
Yeah.
And at some point, you became aware of a fight at the party,
Yeah, I heard a commotion.
right? And it involved Jordan.
I don't know.
While you don't know who exactly was involved in this fight or how it started, you would agree that Jordan doesn't back down in a fight.
Objection,
Correct.
Your Honor. Character evidence, may I be heard?
You may.
Pursuant to Rule 404, this is character evidence, as opposing counsel is attempting to prove a particular character trait of Ms. Patel would make it likely that she would have been involved in this fight, which is not permissible.
Any response?
Your Honor, I'm not using this statement to prove the truth of the matter asserted, or in this case, Ms. Patel didn't back down in a fight, just that Jordan could fight without being drunk.
May I respond, Your Honor?
You may.
The truth of the matter asserted is a hearsay response. What I'm saying that is opposing counsel is attempting to use this statement in order to prove conformity.
Do you have any response to that?
Yes, Your Honor. As my first response stated, I'm not using this to prove that in this case, Ms. Patel didn't back down in a fight, just that Jordan could fight without being drunk.
I'll sustain the objection. You may proceed.
Thank you, Your Honor. I'd like to shift our focus to what happened after the party. Now, after you got back to your dorms, you saw Jordan, isn't that correct?
Yeah.
Right. And you ran up to Jordan, who collapsed as you got there.
Yes.
And then after that, you decided to drive Jordan to the hospital.
Yeah. I had to, obviously.
Now, on this drive, you were trying to determine whether Jordan was drunk or not, correct?
Yeah.
But you couldn't tell.
She smelled like alcohol.
But you couldn't tell if Jordan was drunk, isn't that right?
Not exactly.
Did Jordan say anything on this trip?
Not really.
All right, so Jordan didn't moan or cry out in pain?
No.
Right. Now, Bobby, during this drive, you described it as an eternity, right?
It felt very long, yes.
So not once during this eternity, this drive, did Jordan indicate that they were in pain, right?
Not like directly.
So yes or no, Jordan didn't indicate that they were in pain during this entire drive, right?
Not directly. No, they didn't.
No further questions, Your Honor.
All right. Thank you. Any redirect?
Yes, Your Honor. Ms. Brennan, can you briefly describe Jordan's condition during this, when you saw them collapse?
Well, they were very obviously not well, not responsive, and smelled like alcohol.
So you can confirm that they were injured?
I don't know why someone would collapse if they weren't injured.
Thank you. No further questions, Your Honor.
All right. Thank you. Any recross?
Yes, Your Honor. Miss Brennan, during the drive and during the time after the party that you saw Jordan, Jordan didn't verbally say to you that they were injured, right?
Yeah, but they didn't say much to me at all.
Right, but they didn't say that they were injured, correct?
They didn't say directly that they were injured, yes.
No further questions.
All right. Ms. Brennan, thank you for your testimony. You may step down. Please call your next witness.
The plaintiff now calls Dr. Alex Diaz to the stand.
All right. Dr. Diaz. You may be seated there, and you may proceed when you're ready.
Thank you, Your Honor.
Mm-hmm.
Good morning. Could you please introduce yourself to the court?
Yes, of course. My name is Dr. Alex Diaz.
And could you please briefly describe your educational background?
I earned my Bachelor's of Science in Biology at DePaul University, graduating with a summa cum laude. I then went on to earn my doctorate in surgery at Indiana University, once again graduating with a summa cum laude.
And do you have any other notable achievements?
Yes, I was recognized in 2020 by the American Association of Neurological Surgery with its Distinguished Service Award, which is given to those who make outstanding contributions to the field of neurosurgery. I was also recognized in 2019 as one of the top 50 neurosurgeons in the whole of the United States. So I can guarantee you, if there are 50 people in the United States who can tell you what happened medically in this case, I'm one of them.
Thank you, Dr. Diaz. Your Honor, may I approach the witness?
You may.
Do you recognize this?
I do indeed. This is my curriculum vitae.
And do you keep it in the regular practice of your business?
I do, yes.
I now move to admit what has been previously marked as Exhibit 6 into evidence. Its authenticity has been stipulated.
Any objections to Exhibit 6?
No objection, Your Honor.
Submitted without objection. You may proceed.
Dr. Diaz, do you recall the night of May 2nd?
I do.
And can you tell me what happened on that night?
That is the night that the patient, Jordan Patel, came into the emergency room.
And why did they come into the emergency room?
The patient came in because of complaints of weakness, numbness, and pain to her back, shoulders, and neck.
And did you perform any tests or exams on Ms. Patel?
By the time that the patient got to me, she had already been examined by a few of the nurses, and I was given some of the results.
And what did those results come back as?
Many of the results were drug tests. They all came out negative, but the blood alcohol content was 0.12, which is well above the legal limit for driving.
Your Honor, may I approach the witness?
You may.
Dr. Diaz, can you tell me what this is?
Yes, these are actually the test results that I was just referring to.
And is this a true and accurate depiction?
It is.
And I'm sorry, which exhibit is this?
Exhibit 1.
Okay.
I now move to admit what has been previously marked as Exhibit 1. Its authenticity has been stipulated.
Any objections to Exhibit 1?
No objection, Your Honor.
All right. And Exhibit 1's received.
Thank you, Your Honor. May I proceed?
You may.
So can you tell me about how, what you observed with Ms. Patel?
Patel seemed to be in pain. By the time she got to me, she no longer appeared to be drunk, though the nurses noted that she did seem to be drunk when she first presented herself at the emergency room.
And did you diagnose her with anything?
At that time, I had not done all of the necessary tests to give an accurate diagnosis, so I gave her a neck brace and some muscle relaxers, hoping that the pain would die down. And if the pain would not die down, then it means she had a more serious injury. And if it didn't die down within a month, I asked her to make a follow-up appointment with me.
And could you please briefly describe the purpose of what muscle relaxers are?
Yes, of course. Muscle relaxers are more of a pain reliever. They don't actually heal the muscles or heal anything. They just help the pain subside.
And did you schedule any follow-up appointments?
I did not personally schedule follow-up appointments, but I told the patient to schedule one if her pain continued. And unfortunately, her pain did continue throughout the entire next month, and she did make a follow-up appointment with me.
Thank you, Dr. Diaz. In your medical opinion, what did you conclude about this case?
Well, before I could figure out a conclusion, I had to give the patient an MRI, or magnetic resonance imagery.
And did that reveal anything?
Yes. It revealed something that an x-ray that I also gave her could not reveal. The x-ray just scanned her bones, and there's nothing wrong with them. But unfortunately, the MRI did reveal a right-sided disc bulge and signs of degenerative disc disease, or DDD.
And could you please briefly explain what degenerative disc disease is?
Yes, this is basically the dehydration of the discs in between your spines, between your the bones in your spine. And when this happens, they start to scratch against each other, and it can cause immense pain.
And can you please briefly explain what a right-sided disc bulge is as well?
Yes, for the disc bulge, this is some of the water that was left in her pads between her bones and her spine. This is when some of that gets pinched on the outside, and this furthers the this furthers the pain within her spine.
Thank you. Can you briefly describe your overall conclusion regarding Ms. Patel?
Yes. At this time, the two injuries that I've described before, I diagnosed her with both of those, and I asked her to not play volleyball for another 6 weeks at least until the pain were to go down. And if the pain does not subside, I continue to suggest she not play volleyball, because if she does, then she could suffer permanent injuries.
No further questions, Your Honor.
All right, thank you. Any cross-examination?
Yes, Your Honor. Good morning, Dr. Diaz.
Good morning.
When you received the case of Jordan Patel, the ER physician did the initial exam before calling you. Isn't that correct?
That is correct.
The ER physician filled you in and said Patel told them they had several beers, but couldn't recall exactly how many.
I believe that is what the physician told me.
I now ask that you refer to what has been previously marked and entered into evidence as Exhibit 1.
I believe those were the tests.
Yeah, do you need a copy?
I recall it.
Okay. Patel was tested for their blood alcohol content, or BAC. Isn't that correct?
Yes.
Medically speaking, someone's liver can process about 1 drink per hour. Isn't that correct?
That is correct.
By definition, a 12-ounce serving of beer is considered 1 drink. Isn't that correct?
Yes.
So for context, 0.08% blood alcohol content is legally intoxicated for driving. Isn't that right?
That is correct.
According to this report, Patel's blood alcohol content was 0.12. Isn't that right?
Yes, that is above the legal limit for driving.
Yes. Let's discuss Patel's medical history or records to which you had access. Patel had a prior history of back spasms. Isn't this correct?
Yes, thankfully they had subsided before she presented herself to the emergency room.
They also had a previous cyst on her spine, which was surgically removed.
Without any existing injuries.
After the surgery, however, there was extensive physical therapy.
Yes.
In the ER, Patel informed you that the soreness that she felt was similar to that of a prior volleyball injury. Isn't that correct?
That is correct. That injury had been completely healed by that time. So these are two separate injuries we're talking about.
However, the volleyball injury, she explains, required no medical treatment.
Yes, it healed up on its own.
In fact, Jordan Patel told you initially she did not even want to come to the ER.
I believe she said something like that.
Yes, Patel even claimed to have a 10 out of 10 pain level. Isn't that right?
That is unfortunately true.
She planned to just rest and recover for the start of volleyball the following week.
Unfortunately, that didn't work out for her.
Patel's x-ray in the ER was normal.
That is correct. No fractures.
So the neck brace prescribed was simply a precautionary measure.
In case there was something the x-ray did not pick up.
Yes, and you instructed Patel to not engage in any sports for 30 days.
Correct.
Patel came back in 30 days for the follow-up.
Correct.
And she exhibited sufficient range of motion.
For standard life, yes.
You recommended that Patel not play volleyball for another 4 weeks.
Until the pain subsided, yes.
Because the physical contact playing sports presented a danger of re-injuring Miss Patel's neck. Isn't that
Yes. If she is in pain at any time, I would strongly encourage her to not play volleyball. If she's still in pain and she plays volleyball, she's just going to re-injure her neck and have permanent lifelong damage.
Yes. During the follow-up appointment, you ordered an MRI which can show injuries to soft tissues.
Correct.
The MRI revealed mild DDD and a mild bulging disc. Isn't that correct?
The bulging disc was severe.
DDD indicates that a patient can be predisposed to spine injuries.
That is correct.
In fact, it is your conclusion that Patel's DDD contributed to the injury.
That and the whiplash she sustained at the party she told me about.
In sports, like volleyball, are the most common cause of disc problems. Isn't this correct?
Most of the time, but that is not the case in this situation.
However, they are the most common cause.
In most cases, yes.
Medical care for disc problems, such as anti-inflammatory medication, physical therapy, typically focuses on preventing further damage. Isn't this correct?
That is correct.
And you typically prescribe some type of narcotic pain medications to individuals with severe pain. Isn't that correct?
Yes. If her pain stayed 10 out of 10 the entire time during our appointment, I would have prescribed this medication. But thankfully, it went down throughout the appointment, and I only had to prescribe muscle relaxers.
So you did not prescribe the medication you would normally give to a patient who exhibits severe pain.
Yes, that is correct.
Okay. Ultimately, in your own words, given the level of pain Patel was experiencing, you only prescribe a non-addictive muscle relaxant and a physical therapy for 6 months, even though Patel claimed she had a 10 out of 10 pain. Isn't that correct?
Once again, when she first arrived at the ER, she said 10 out of 10 pain. At that exact moment, it would have been a good idea to give her the highest pain relaxers, pain relievers. But as the appointment went on, her pain went down, as it does after an injury, and I was not forced to give her the strongest pain relievers.
And you believe with the pain relievers who do not heal injuries, you believe that she would fully recover?
Can you restate your question, please?
Yes, previously on direct examination, you explained the nature of pain relievers and how they do not heal injuries, that they minimize the pain.
That is correct.
Yes.
Not taking them, it would make it hurt, but it doesn't slow down the healing process whatsoever.
However, you still state, though, that you believe that she would fully recover without any medication that would help this process.
I hope so, but at this point, there's no way to tell.
And re-injuring the neck could cause permanent damage or accelerate the degenerative disc disease she has.
That is correct.
In your sworn statement, there is no indication that you thought Patel would ever be able to play volleyball again. Isn't that correct?
Can you restate that question?
Yes, I think I might have misspoke there. In your sworn statement, there was no indication that you thought or told Miss Patel she would never be able to play volleyball again.
It's still possible she can play again if her pain goes down, but if her pain does not go away, she cannot play volleyball.
And you cannot definitively say what caused Patel's injury?
I can tell you, through all of my expertise and the information that I was given, that the most likely cause of her injury was whiplash that she sustained at a party.
Thank you. No further questions, John.
All right, thank you. Any redirect?
Yes, Your Honor. Dr. Diaz, when you saw Miss Patel, can you describe how she appeared?
By the time I saw Miss Patel, she no longer appeared intoxicated, but she did seem to be in immense pain.
Immense pain. Can you further elaborate on that?
Yes, she told me that her pain level was 10 out of 10. We use a 1 to 10 scale when asking patients how bad their pain is, and she said 10, which is the worst possible pain. So when I first saw the patient, she was in the worst pain you can imagine.
And does that 10 out of 10 pain typically correlate to a severe injury?
I would say most of the time.
No further questions, Your Honor.
All right, thanks, Ms. Baker. Any recross, Mr. Tiernan?
Yes, briefly, Your Honor. On redirect, opposing counsel had mentioned that you, as stated previously, Ms. Patel described a 10 out of 10 pain.
At the very beginning of our appointment, yes.
And this would, as she stated, this would indicate a severe injury. Isn't that correct?
Unfortunately, yes.
However, the medication you prescribed that you would typically prescribe for serious injuries with severe pain was not prescribed to Ms. Patel. Isn't that correct?
By the time our first appointment had concluded, I had not yet ordered the MRI, meaning I only had results from the drug tests and the x-ray. None of these showed a severe injury. So by the time she left that first time, I did not know that she had a severe injury. It was not until the follow-up appointment that we found the severe disc bulge.
No further questions, John.
All right, thank you. Thank you for your testimony. Doctor, you may step down. Plaintiff, please call your next witness.
The plaintiff rests, Your Honor.
All right, do we need a break before we proceed with the defense?
The defense is ready, Your Honor.
Okay, good. All right, please call your first witness.
The defense calls Cameron Miller to the stand.
All right, Ms. Miller, you may be seated there, and Mr. Tiernan, you may proceed when you're ready.
Please state your name and spell it for the court.
My name is Cameron Miller, Miller.
And why are you here today, Miss Miller?
That's a great question. Why am I here today? I mean, plenty of legal adults have parties and don't end up in court. Basically, Jordan Patel is suing me over something
Objection,
that
Your
isn't
Honor.
even-
Narrative.
Go ahead.
The opposing counsel asked a question that was very vague. It called for narrative, and then the witness continued to go into a narrative.
Okay, any response?
Yes, Your Honor. I'm simply asking this witness to explain why she is here in court today. I think this is pertinent for the jury to not only understand who Cameron Miller is, but for the court, just in her perception of why she is here and why she's being sued.
Your Honor, if I may respond.
Uh-huh.
Opposing counsel asked why she was here. Ms. Miller did not just say because I'm defending myself, but continued to elaborate and go into a narrative of things she happened at the party that she thought were wrong and unreasonable.
All right, so I will overrule the objection. However, please make sure you confine your answers to the question, and
Yes, Your Honor.
you may proceed.
Yes, Your Honor.
Oh, would you like this witness to complete her, or would you like me to move on to the next question, Your Honor?
Well, why don't you take control here and either follow up on that question or go to your next question?
Of course, Your Honor.
However you want to proceed.
Yes. Ms. Miller, you explained that Ms. Patel is suing you. Can you explain why Ms. Patel is suing you?
Yes, she claims to have injured her neck or back or something at the party she wasn't even invited to.
And why did you have this party?
I never wanted to have a big party in the first place. I just wanted a small gathering with some of my closer friends. But Morgan had been trying since high school to get me to collaborate on throwing a party.
And how did it turn into such a large party?
Morgan's reposting turned my status update into a invite to everyone without my approval.
And what did you do to contribute to this party?
All I did was contribute the house and pick the date. Everything else was Morgan. She bought the beer, which was way more than I expected, by the way, and she helped set up the ping pong tables and solo cups. I couldn't do much to help at the time because I was injured, but I didn't think there'd be much to do because I was expecting a small gathering.
And how did this party start?
Everyone started showing up around 7 p.m., and the party kept getting bigger and bigger until there were around 150 people there. I got so overwhelmed and tired of saying be careful that I decided to go to my room and
Objection, Your Honor. Narratives.
Okay, response?
My witness is simply explaining the beginning of this party. My question asked how the party started, how the beginning of the party went, and my witness is simply elaborating on her experience of the beginning of the party and what she was doing at that time.
Okay.
Your Honor, if I may respond.
Yeah.
This witness did not just talk about the beginning of the party, but she went on to talk about different events that happened further later on in the party, as we already know. We've heard testimony, different things that happened hours into the party. That's now what she's testifying to.
Okay. Again, on direct, those should be open-ended questions, but we can't just ramble on. So I don't know how to sustain that other than to again say, just try to answer the question that's asked, and you can direct her to where you want her to go.
Yeah, sure.
Okay.
Yes, Your Honor.
Once you had seen that about 150 people were at your house, how did you feel? What did you do?
I was overwhelmed and decided to go upstairs where I saw Jordan Patel jumping on my bed. Once she saw me, she slipped and her face smashed into my Legos, and it was a mess.
And how did you respond to Miss Patel falling on your Legos?
Well, after Jordan quickly stood up, I collected myself and told her to get out, clearly meaning out of my house and not just of my room.
And what did you do after telling Jordan Patel to get out of your house?
I was trying to collect my Lego pieces back together when I heard a ruckus coming from downstairs.
And what was that ruckus?
I went downstairs to find Jordan Patel on the living room floor with her back against the wall and her nose bleeding. I saw someone standing next to her and assumed they had gotten into an altercation, but Jordan's friend Bobby helped her up and she walked off without even a limp.
And how did you respond to this supposed altercation?
I expressed how upset I was that Jordan was even still in my house after I had told her to get out an hour earlier. But she and Bobby looked perfectly fine to me, but I later found out that Jordan claims to have injured her spine this night.
Did you have any idea that Miss Patel had sustained any injury beyond a bloody nose?
No, of course not. If I thought anyone was really injured, I would have called an ambulance for sure.
And what happened after Miss Patel left your house?
I needed a breather, so I found a quiet spot in a chair and just waited for the party to be over. Everyone had left around 1 a.m., and I thought it was all over, but now look where we are.
What do you mean by that?
I am definitely not a party girl. I sit at home most weekends just so I can build Legos. And the
Objection,
only
Your
reason...
Honor. Relevance.
Any response?
Your Honor, my witness is explaining the nature of why she wanted this party not to happen. She's explaining how she is a more of a homebody and more reserved, and she's explaining why she would not be inclined to have such a large party. Just going into explanation of this and into explaining her point of view on her involvement in this party, which she is being sued over, is perfectly relevant in this case, Your Honor.
Your Honor, if I may respond.
You may.
This witness testifying as to her being a homebody has no pertinence to this case. If opposing counsel would like to explain why that is relevant, why we are here today is whether or not Ms. Miller adequately monitored her party, not whether or not she is a homebody and enjoys parties.
All right. Any response to that?
Yes, Your Honor. I would just repeat that she's a non-experienced party hoster, and so that would explain some of the nature of this case and why she's being sued. She's just explaining that she was an inexperienced party host and that this is not what she usually does, Your Honor.
All right. It's overruled. You may continue.
Thank you, Your Honor.
I'm going to repeat my question. What do you mean, look where we are?
As I was saying, I stay at home most weekends, and the only reason this party happened was because Morgan talked me into it. And I not only ended up with a big party that messed up my house, but now I have someone trying to sue me over something that isn't my fault.
Miss Miller, did you serve alcohol to anyone who was visibly drunk?
No, of course not. I was just trying to...
Objection, Your Honor. Lack of personal knowledge, 602. May be heard.
You may.
This witness is not a medical expert. They would not be able to testify as to whether somebody is medically, by the intoxication level of 0.8, intoxicated or not when she is serving them.
Your Honor, if I may respond.
You may.
My question asked if she served alcohol to anyone who was visibly drunk, not medically drunk. So this is just based on my witness's rationally based perception of what that person, whether they may have been intoxicated, whether they were visibly drunk and not medically drunk. So I'm not calling for an expert testimony, just simply based on her perception and experience at that party, Your Honor.
All right. You can answer the question. You can explore it on cross if you need.
Yes, Your Honor.
Go ahead.
Yes, Your Honor. So I'm going to repeat my question. Did you serve alcohol to anyone who was visibly drunk at your
No,
party?
I did not.
And what do you want the court to know about this lawsuit?
First of all, I didn't even invite Jordan Patel to this party.
Objection, Your Honor. Question calls for narrative.
That's sustained.
Thank you, Your Honor.
And I would just ask one more specific question. Were you there for the altercation that happened in your house?
No, I was not. I only heard the noise from upstairs.
No further questions, Your Honor.
All right. Thank you. Any cross-examination?
Yes, Your Honor. All right, good morning, Miss Miller. I want to talk about your claims that this party was Morgan's party. Morgan DeLuca pitched the idea to you, correct?
Yes, she did.
And you thought about it and then agreed to it, right?
After much convincing, yes, I did.
And this party was at your home, correct?
It was.
Serving your alcohol.
I bought the alcohol, but Morgan picked it up, and she picked up more than I was expecting.
So alcohol purchased with your money, correct?
Yes, it was.
And you had the ability to shut the party down anytime you decided, correct?
I think if I tried, I don't think Morgan would have let me. She's a pretty
Objection,
big
Your Honor.
Morgan girl.
This is outside the scope of my witness's knowledge. As established on direct examination, this witness is not an experienced party host, and so would not have experience on how to control parties, on whether her ability to shut down a party. Opposing counsel has asked whether she thinks my witness would have a capability of doing that. Again, this is outside the scope of my witness's knowledge.
Okay.
Your Honor, if I may respond?
You may.
This witness can testify as to if they had the ability, even the physical ability, to shut down the party.
All right. I'll overrule the objection. You may answer the question.
Yes, Your Honor.
Ms. Miller, is it your testimony today that you did not have the physical ability to stop this party from continuing?
I mean, there were around 150 people there, but Morgan, she loves her parties. I think she would have kept it going, even if I tried to stop it.
But to be clear, this party was at your home, not Morgan's home.
It was, but Morgan was co-hosting.
And so, to redirect you to my question, if you wanted to, you could have had the physical and used your physical ability to shut the party down.
Maybe, but me against 150 people, I don't know how'd that go.
And you do admit that you've thrown a grand total of one party, correct?
Yes.
This was the party on May 2nd, 2020.
Yes.
So Morgan was the party planner,
Yes, she was.
but this was your party.
We were co-hosting it.
Let's talk about the invitations to this party. You have a cell phone, right, Ms. Miller?
I do.
And a Twitter account.
Yes.
And you allowed Morgan DeLuca to post invitations on them, correct?
She posted something saying that I was having a party, but it wasn't an invitation, and if people perceived it at that, it was against my will.
You never took this statement down, did you?
I did not.
Now, I want to move on and talk about the consumption of alcohol at your party. You didn't charge anyone for the beer that you served, correct?
No.
You gave it away for free, right?
That's typically what happens at parties.
And the purpose of this party was to throw the semester's biggest rager, right?
That's what Morgan wanted.
And alcohol was a big part of that plan.
Yes, it was for legal adults.
So you purchased 2 kegs of alcohol and put one in the yard and one in your house.
Yes, Morgan did.
And people could just serve themselves whenever they wanted.
They could.
And you did nothing to monitor how much people were drinking, did you?
I did. I was at the keg and I was watching who was getting some.
Oh, that's right. The one thing you could think of doing was to fill people's cups up yourself from the keg. Is that right?
That way I could see who was getting alcohol and who wasn't.
And to go around and top people's cups off with more alcohol.
Again, so I could see who was getting it and who wasn't.
And you never stopped anyone from drinking alcohol. You only gave more alcohol. Isn't that right?
Yes.
Let's talk about the effect that all of this free beer had on your guests. By 10:07 p.m., you saw Morgan DeLuca standing with a red Solo cup in her hand, like the ones that were by the kegs, right?
Yes, I did.
And Morgan was noticeably slurring their words. Isn't that right?
She was.
And Morgan told the guests that we're just getting started, correct?
Objection, Your Honor, hearsay.
A response?
Your Honor, under Rule 802D2D, this is party opponent's agent. Morgan DeLuca, as Miss Miller has been testifying again and again, was helping her with the party, was the co-host of the party, so it is an exception to hearsay.
Your Honor, if I may respond.
You may.
This rule explains somebody speaking on behalf of Miss Miller, and as Miss Miller has explained, she did not want this party to get going as the statement by Morgan DeLuca says, by opposing counsel. So she's not speaking on behalf. In fact, it is actually completely opposite of what Miss Miller's wishes would have been for that party. And so this exception does not apply to my hearsay objection, Your Honor.
Your Honor, if I may be heard. Regardless of this witness's intentions for the party, Miss Miller and Morgan DeLuca were working together to host the party. So it was a statement made by the agent to party opponent.
All right, well, I'll take that under advisement. In the meantime, you can answer the question.
Yes, Your Honor.
And Morgan, Miss Miller, told the guests, we're just getting started, correct?
That is what she said, yes.
And Morgan DeLuca slurring their words and making that statement could have indicated that they were intoxicated. Isn't that right?
I guess, but I'm not really sure.
You did nothing to find out if Morgan was intoxicated, did you?
I did not.
And more importantly, you didn't stop the access to alcohol that Morgan or any of your other guests had, right?
No, I didn't.
About an hour later, you went upstairs and saw Jordan Patel jumping on your bed, correct?
Yes, I did.
And Jordan Patel stumbled and fell to the ground, isn't that right?
Yes, right into my Legos.
After Jordan fell to the ground, you didn't think to check if they were intoxicated, did you?
She stood up rather quickly and walked out before I could do anything. She didn't even apologize.
Well, you testified on direct that you yelled at Jordan, isn't that right? You told them to get out of your room, correct?
Yes, I told her to get out.
I'd like to talk about that statement. Now, when you told Jordan to get out of your room, you were inside the room. You never said, get out of my house, correct?
I said get out, which I thought clearly meant out of my entire property or house.
Well, once you realized that Jordan was still in your home and you went downstairs, you never told Jordan to leave your house then, did you?
After I saw her downstairs, she left.
But you didn't know for sure if she left the property. You just know she walked away.
She walked out of my house.
Let's shift focus to something that occurred later on in the party, when you did see Jordan still in your home. And about an hour later, you heard a ruckus downstairs, as you testified on direct.
I did.
You heard yelling, thumping, and screaming. You went downstairs.
Yes.
And you saw Jordan on the floor, blood dripping down her face, correct?
I assumed it was probably from her smashing her face into my Legos earlier, but yes.
Well, from seeing Jordan with blood dripping down their face, you inferred that there had been some altercation, correct?
That's what I thought, yes.
And at that point, after seeing Jordan had gotten into a violent fight, you didn't think to check if Jordan was intoxicated, did you?
Like I said earlier, she stood up, shrugged her shoulders, and left rather quickly before I could say anything.
And after that altercation, instead of stopping the access to beer that your guests had, you sat in a corner and let the party continue until 1 a.m. Isn't that right?
Yes, people were still there.
No further questions, Your Honor.
All right, thank you, Ms. Bach. Any redirect?
Yes, Your Honor. Who hosted this party, Miss Miller?
Morgan and I were co-hosting.
And who controlled the invites for the party?
I invited a few close friends, but Morgan sent out all the invitations to people without my approval.
And did you tell Jordan Patel to leave your party?
Yes, I told her to get out.
And did this mean off your property?
I thought it was pretty clear that's what it meant. Yes.
And when did this? When you said get out? When did you say this?
I said it after I saw her jumping on my bed.
Was there an altercation after you said get out?
Supposedly, yes.
Yes. No further questions, Your Honor.
All right, thank you. Any recross?
Yes, Your Honor. Ms. Miller, you just testified on redirect that Morgan sent out the invitations, correct?
She reposted something that I was having a party.
So you
and
admit
invited.
that they were invitations?
What she said were invitations. My tweet was not.
And you never deleted those invitations on your account, did you?
Objection, Your Honor. Asked and answered.
Overruled. You may answer the question.
You never deleted those invitations on your account, did you, Ms. Miller?
No, I did not.
No further questions, Your Honor.
All right, thank you. Ms. Miller, thank you for your testimony. You may step down, and defendant, please call your next witness.
The defense calls Morgan DeLuca to the stand.
All right. You may be seated there, Mr. Luca. And you may proceed when you're ready.
Thank you, Your Honor.
Mm-hmm.
Please state your name for the court.
The name's Morgan DeLuca. I'm the cool, the savvy, and yeah.
Where do you attend college?
I go to Harmony State University.
And prior to Harmony State, where did you live?
I lived in a small town in Indiana, but I never really felt I could reach my full potential in that town.
And why did you choose Harmony State for college?
Well, it had a really good school, and I just knew that I wanted to go into communications, and they had just a really good place for that.
I want to direct your focus to Cameron Miller. Are you familiar with Cameron?
Oh, me and Cam have been besties for such a long time. We grew up in the same town. We even went to the same university.
I want to focus now on a college party that happened at Cameron Miller's home on the night of May 2nd, 2020. Did you attend this party?
Oh yeah, I practically planned it.
All right. So, were you involved in the planning?
Yeah, big time.
Had you planned any parties in the past?
Yeah, a few. I'm a big fan of campus nightlife.
Who sent out the invitations to this party?
Well, I took Cam's phone and sent out a few on Twitter, but then I also retweeted it, and well, I'm kind of an influencer, so I told everyone it wasn't going to be a lame get-together, that I'd kind of said on Cameron's page.
All right, now I want to talk a little bit more about the details of the plans for the party. Where was it going to be?
It was going to be at Cameron's house. I mean, I wasn't going to throw it in my dorm.
And how many people did you invite? How many people did you want to be there?
Well, I invited about 50 to 70.
And was there going to be alcohol there?
Yeah, I took Cam's credit card and went down to Moe's and bought some alcohol.
And what kind of alcohol did you purchase?
I got some beer. I think it was Bud Light.
And how much did you purchase?
I got 15.5 gallons of it.
Right. And at any time in the planning of this party or sending out the invitations, did you say that this was a bring your own alcohol kind of a party?
Oh, no. No, I was going to provide it.
All right, so just to clarify, only the alcohol that you provided was supposed to be there.
Yeah.
As somebody who has planned parties before, did you think that 2 kegs of Bud Light was too much for 50 to 70 people?
Oh, no. I thought it might not be enough, honestly.
Now, I want to talk about the night of the party. Do you know how many people actually ended up going?
Well, it was way more than I expected, and definitely way more than Cam had expected.
So since more people showed up than you had planned for, did you purchase more alcohol?
No, I didn't.
All right, I want to talk about what you saw that night. But first, are you familiar with Jordan Patel?
Yeah, I kind of know Jordan through Cam. I think they were on the same volleyball team together.
Are you familiar with any reputations that Jordan had in school?
Well, Jordan's kind of known to be an exaggerator, always looking
Objection,
for
Your Honor. Character evidence, may I be heard?
You may.
Pursuant to Rule 404, opposing counsel is attempting to use the fact that Jordan's an exaggerator to prove that Jordan would have not been in pain during this party, which is inadmissible under that rule.
All right, any response?
Yes, Your Honor. This is a reputation going to the truthfulness of Jordan Patel.
May I be heard?
Let me make sure I understand your response, though. So you're listing the testimony for what purpose?
Your Honor, being an exaggerator or not, that reputation would go to the truthfulness of Jordan Patel, of the witness, or not of the witness, but of Jordan Patel.
So you're trying to get this to impeach Jordan Patel. Is that it?
Not necessarily to impeach, Your Honor, just to go to the truthfulness or untruthfulness.
Okay, all right, you may proceed, yes.
Your Honor, opposing counsel has not laid proper foundation that this is indeed a reputation Jordan Patel has.
Your Honor, if I may respond.
Yes, please.
My question was, were there any reputations that Jordan Patel had on campus? So this would be referring to a reputation.
Okay, I'm going to overrule the objection. Let's see where this goes. I'm not sure that it's ripe yet, but go ahead.
Yes, Your Honor.
Thank you, Your Honor. I'll re-ask my question. Were you aware of any reputations that Jordan had on campus?
Well, Jordan was always known to be the bench warmer on the volleyball team, and she was always looking for attention, always exaggerating, and she just always wanted to be the star of everything.
All right, let's turn back to the night of the party. Was Jordan there?
Yeah, she showed up at some point.
And at some point during this party, there was a disturbance. Did you see what happened?
Not really. I was outside and I walked inside the house after I saw a bunch of people kind of flooding in. And all I saw was Jordan just kind of laying on the ground, and then she got up and just left. I don't know what the big deal was.
All right, so when Jordan was laying on the ground, did Jordan say that they were in pain?
No, she didn't say anything.
Did Jordan ask for help getting up off the ground?
No, we had a friend actually ask to help her, and she just refused and walked out.
So when Jordan walked out, was Jordan stumbling or walking unsteadily?
Not really. She just walked straight out of the house.
Did you hear Jordan slurring any words as she walked out?
Not really, no.
No further questions, Your Honor.
All right, thank you. Any cross-examination?
Yes, Your Honor. Ms. Tuluka, I'd like to talk about whose party this was. Your role was to get the people, correct?
Of course, and get the beer.
And to do the organizing for the time and place?
Yep.
And the party was held at Cameron's house.
Yeah, I wasn't gonna hold it in my dorm.
And it was Cameron's money that paid for everything.
Yeah, I used Cam's credit card.
Including the alcohol that was provided at the party.
Yeah.
And this was supposed to be a party of epic proportions.
Of course, all my parties are.
And you sent out invitations for this party.
Yeah.
Invitations that you sent out on Twitter.
Mm-hmm.
That was sent on both yours and Cameron's account.
Yeah, I sent them both out.
Your Honor, permission to approach the witness?
Yes.
Ms. DeLuca, do you recognize this document?
Yeah.
Can you identify this document?
That is the post I made on Cameron's Twitter account.
And is this a true and accurate document to your knowledge?
Yeah, that looks right.
Your Honor, plaintiff now moves to enter Exhibit 4 into evidence. Its authenticity has been stipulated.
Any objection to Exhibit 4?
Yes, Your Honor, I would object to hearsay.
Okay, why don't you tell me what your hearsay objection is?
Your Honor, if I can see the exhibit, the first tweet that has shown up is a tweet from Cameron Miller, not Morgan DeLuca.
Okay. And so the full objection is?
Hearsay, Your Honor, because not only is this an out-of-court statement made on Twitter, but this is also hearsay within hearsay because one of the statements within the tweet was not even made by Ms. DeLuca herself.
You're talking about the one from Delicious?
Your Honor, the first tweet from Cameron Miller was not made by Ms. Morgan DeLuca. And the entire document being an out-of-court statement.
Okay, response, you can go back up to the...
Yes, Your Honor. I've already laid foundation that Ms. DeLuca did take Cameron Miller's phone and did send out both of these tweets herself using her on hers and Cameron Miller's account. Second, and this is admissible under 801 D2D, which is party opponent. And I am not using this to prove the truth of the matter asserted, but rather the effect that this post would have on those receiving these tweets.
Any response to that?
Your Honor, I believe that this would be being used to prove the truth of the matter asserted, essentially, that there were a large number of people invited.
Okay, well, I'm going to overrule the objection. It seems to be, as I understand it, this is a statement by the defendant offered by the plaintiff against the defendant as an opposing party. Is that right? Is that right?
Yes, Your Honor.
And so it's not even hearsay under 801 D2. Before we continue, though, there's another statement in there. Did you want to talk about that at all? From Delicious. There's not a party, right?
Yes, Your Honor. That was the second part of my objection, was to just the whole statement, the statement as a whole being an out-of-court statement being used to prove the truth of the matter asserted.
Okay, any response to that?
Yes, Your Honor. I am not using these statements within this tweet. I am just using the fact that this tweet was sent out to the people coming to the party.
Okay, so again, I'm going to overrule the objection to the Exhibit 4 with respect to Ms. Miller as a statement by a party opponent offered against the party under 801 D2 with respect to Delicious. I'll overrule that as not being offered for the truth of the matter, but for context for the, and perhaps under 810C2. So you may proceed, and it's admitted over your objection.
Yes, Your Honor. Mr. Luca, this is Cameron Miller's Twitter account, isn't it?
Yeah.
And people receiving this tweet would see that's from Cameron Miller.
Yeah.
And Cameron didn't stop you from using their phone.
Well, I just kind of took it.
And nor did Cameron stop you from using their credit card.
No.
In fact, when you approached Cameron with the idea of this party, they said, let's do it, right?
After a ton of convincing, I even kind of had to butter her up a little bit by taking her to her favorite taco shop.
So that's a yes. Miss Miller was on board with this party.
Yes.
Let's take a closer look at what was going on at the party. The house was packed with people, right?
Yeah.
And the large backyard couldn't hold everyone.
Yeah, people were just kind of flowing inside.
And you were mostly in the backyard dancing.
Yeah.
And no attendance was taken.
Not really. I mean, we don't really take attendance at college parties.
And you don't know where all those people came from, do you?
Well, some of them I knew, but some of them I didn't.
But the party was packed, right?
Yeah.
And you were drinking beer.
Yeah.
And Cameron was drinking beer.
Yeah, just a little bit to calm her down.
But Mr. Luca, you don't know how much beer you don't know the exact amount of beer they took, right?
Not the exact amount, but just what I saw her drink.
And you had 2 kegs of beer for that party.
Yeah.
And you thought the party was a hit.
It was.
And you weren't concerned when furniture was being knocked over?
I mean, it can just be put back up, and that happens at all college parties.
But you weren't concerned about that, were you, Mr. Luca?
No.
And 15 minutes later, you heard a commotion.
Yeah.
Now, I'd like to talk about that commotion. You came in and you saw Jordan Patel on the ground gasping for air.
Yeah.
And you weren't concerned about that?
No, because one of our friends offered to call an ambulance and offered to help her up, and she just took off and went out the door.
But Ms. DeLuca, if I can redirect you to my question, you weren't concerned that Jordan Patel was on the ground?
No, she got up and left on her own.
In fact, on direct, you mentioned that Jordan Patel was an exaggerator.
Mm-hmm, she is.
So you wouldn't have taken Jordan Patel seriously in that moment, would you?
No, not unless she would have said something about her injuries.
And you weren't concerned when you saw Jordan's face bleeding?
No, because she didn't ask for help. She seemed fine.
And Cameron was standing there.
Yeah, looking horrified, if I might add.
And someone who you describe as our friends came to help Jordan.
Yeah.
And Jordan just shrugged it off.
Exactly.
And you didn't try to interfere?
No, I mean, they were just going to help Jordan.
And Cameron didn't try to interfere?
Mm-mm.
Despite the clear fact that there was an injury on Jordan's face?
Well, she didn't seem to need help.
And Jordan And Jordan left the party?
Yeah, walked out all on her own.
And no one knew what to do at that point?
Yeah, but I wasn't going to let this party be a flop.
So the party just simply resumed?
Yeah, what else was there to do?
No further questions, Your Honor.
All right, thank you. Any redirect?
Yes, Your Honor.
All right.
On cross-examination, opposing counsel talked about if you knew where people came from to this party. How many people did you plan to be at this party?
I invited 50 to 70.
Right, and how many showed up?
Plenty more than that.
Did you purchase any more alcohol for the party?
Nope.
Right, so just to clarify, there were more people but not more alcohol than you had planned for.
Yeah.
Right. Now, opposing counsel also seems to reference that you didn't offer to help Jordan up. Did anyone offer to help Jordan after they had fallen down or after they had blood coming down from their face?
Yeah, one of my friends did.
Right. And how did Jordan react to that?
Well, she just kind of shrugged them off and left on her own.
No further questions.
All right, thank you. Any recross?
Briefly, Your Honor. Mr. Luca, you did see Jordan's blood dripping down from Jordan's face, correct?
Yeah, but I was pretty far away.
Yet you didn't try to go up to them and see what was happening?
I mean, other people were doing that. I didn't feel the need to.
Yet you say you were the host of this party, yet you didn't try to see what was going on?
I mean, I saw what was going on. I just saw other people helping Jordan.
No further questions, Your Honor.
All right, thank you. Thank you for your testimony. You may step down. Defendant, please call your next witness.
Yes, Your Honor. The defense calls Dr. Joe Strickland to the stand.
All right. Strickland, you can be seated there. And Ms. Favors, you may proceed when you're ready.
Thank you, Your Honor. Please state your name for the record.
My name is Dr. Joe Strickland.
And Dr. Strickland, where are you currently employed?
Currently, I have my own private practice, which I've been running since 2014. I am also employed at the Metropolitan Hospital and have been there since 2011, and I also work at the Central Veterans Hospital since 2012.
Do you have any specializations?
Yes, I specialize in spine and musculoskeletal interventional medicine.
Can you briefly describe your educational background?
Gladly. I earned my bachelor's in chemistry and science from Purdue, and then 4 years later, I went on to earn my medical degree from IU. I did my internship at IU Hospital in Indianapolis, and then my residency at Truman Center East Hospital. After that, I did my fellowship at Johns Hopkins, where I specialized in spine and musculoskeletal interventional medicine.
Let the record reflect I will now be showing opposing counsel what's been marked as Exhibit 7.
All right.
Permission to approach the witness, Your Honor.
You may.
Dr. Strickland, can you identify this document for me?
Yes, that is my CV.
Is this an accurate depiction of your curriculum vitae to your recollection?
Yes, it is.
I now move to enter Exhibit 7 into evidence. Its authenticity has been stipulated.
Any objections to 7?
No objections, Your Honor.
It's received without objection.
Thank you, Your Honor. Dr. Strickland, do you have experience testifying in court?
Yes, I have done it upwards of 250 times.
So what brought you to this trial today?
When Cameron Miller's attorneys approached me and asked me to do an independent review of the medical facts asserted.
What exactly did you review to prepare for this trial?
The records I reviewed included the ER reports, the radiology images, and the reports from that, along with documents from the follow-up appointment done by Dr. Diaz, and all previous records, medical records of Jordan Patel's.
Did you examine the plaintiff yourself?
Yes, I did. I did examine Jordan Patel a few months after the incident.
Now, before we get into the specifics of your examination, I want to ask, did you form any conclusion about the plaintiff before we talk about your tests?
Yes, as far as I could tell, Jordan Patel had suffered a soft tissue injury, which was relatively minor and would resolve itself within a few weeks.
Well, let's talk a bit more about the testing that helped you form this conclusion. Now, remind us, when Jordan Patel presented at the ER on May 2nd, 2020, how did they describe the event that prompted their visit?
Jordan Patel, in the medical documents that I reviewed, described a punch to the chest where they fell backwards and to the left and hit their head on the ground.
Well, let's break that down a bit more. You mentioned the plaintiff struck their head. Did they complain of any pain in their head?
No, they did not complain of any pain to the head. However, they did complain of some pain to the shoulder and neck.
Well, were any tests run to examine the shoulder and neck?
Yes, during the ER visit, there was an X-ray that Jordan Patel. There was an X-ray taken of Jordan Patel's neck, and at the follow-up appointment a month later, there was an MRI done to see if there was anything in this soft tissue.
Now, Dr. Strickland, you mentioned Jordan Patel claimed they had pain in their shoulder and neck. Did they claim there was pain in a specific shoulder?
Yes, they specified that the left shoulder was where the most pain was.
Now, you mentioned there was an X-ray taken on May 2nd, 2020. I want to talk about that X-ray first. Who conducted this X-ray?
Dr. Alex Diaz performed the X-ray.
And what did this X-ray reveal?
The X-ray revealed that the lordotic curve was normal and that there were no fractures or breaks.
Can you explain a lordotic curve just in layman's terms?
Yes, the lordotic curve is the natural curvature of the spine. Since the spine is not perfectly straight, there is a slight curve to it. The bounds of what is considered normal for the curve would be the lordotic curve.
Now, you mentioned the lordotic curve, and this X-ray was normal. So what does that signify in the plaintiff's case?
The fact that the lordotic curve was normal meant that any muscle or tissue would not be irreparably damaged, or there was no long-term damage, because that would have destroyed the lordotic curve or malformed it.
You also mentioned there was an MRI taken. I want to talk about that now. Who conducted this MRI?
This MRI was also done by Dr. Alex Diaz at the follow-up appointment a month after the incident.
And did you review this MRI yourself?
Yes, I did.
Let the record reflect I will now be showing opposing counsel what's been marked as Exhibit 2.
Will so reflect.
May I approach the witness, Your Honor?
You may.
Dr. Strickland, can you identify this document for me?
Yes, this is Jordan Patel's MRI taken about a month after his injury.
And is this an accurate depiction of the MRI to your recollection?
Yes, it is.
Well, Your Honor, I now move to enter Exhibit 2 into evidence. Its authenticity has been stipulated.
Any objections to Exhibit 2?
No objections, Your Honor.
All right, it is admitted.
Thank you, Your Honor. Dr. Strickland, using this exhibit, can you explain what exactly did this MRI reveal?
Yes, this MRI shows a bulging disc to the right, which was, as far as I can tell, asymptomatic and pre-existing, meaning it didn't harm or contribute in any way to Jordan Patel's injury.
Now, you mentioned this condition is pre-existing. What exactly does that mean?
Well, pre-existing would mean it was there before the incident. It was not caused by whatever occurred on the night of May 2nd at the party. And asymptomatic would mean that it didn't do anything. It wasn't affecting Jordan Patel in any way. It wasn't harming him. It wasn't helping him. It just kind of sat there and did nothing.
Now, you mentioned earlier the plaintiff complained of pain on their left side. So how did a right-sided disc bulge affect your ultimate conclusion?
The fact that the was a right-sided disc bulge, and there was pain on the left side. Further contributed to my diagnosis that it was pre-existing and asymptomatic, because the pain and the disc pathology that was going on in Jordan Patel's neck did not align in any way, shape, or form, so they couldn't have caused each other.
Now, we've talked about this x-ray, we've talked about this MRI. I want to discuss your independent examination of Jordan Patel now. Now, when you examined Jordan Patel, did you examine her neck, and left shoulder?
Yes, I did.
And what did you find?
There was no tenderness, there was no muscle spasms, there was nothing to indicate that there was any long-term injury resulting from this.
So if there was no muscle spasms to your recollection, what explanation do you have for Ms. Patel's complaints of pain?
The only explanation that I can think of for Ms. Patel's current complaints of pain, it would be symptom magnification.
And what is symptom magnification, Dr. Strickland?
Symptom magnification is when a patient, either consciously or unconsciously, magnifies or alters what pain they're experiencing.
Now, we've discussed all of your testing and examination. I want to briefly revisit your conclusion that you mentioned earlier. Can you restate your conclusion and the reasoning behind it?
Yes. What I concluded was that Jordan Patel had suffered a soft tissue injury to her neck. And the reason that I concluded this was because any disc pathology in her neck, or shoulder for that matter, would not correlate with any pain that she was experiencing. And there would be no long-term results from any injury caused.
How long should it have taken for Jordan Patel's injury to heal?
Most likely 2 to 3 weeks, definitely within a month.
Is she healed at this moment?
As far as I know.
Will any permanent disability develop?
It is not likely, no.
No further questions at this time, Your Honor.
All right, thank you. Any cross-examination?
Yes, Your Honor. Good morning, Dr. Strickland. You're an expert witness, correct?
That is correct.
And you're paid around $800 an hour for your expertise?
Yes.
And that you've testified in court many times before, as mentioned previously, around 250 times?
Yes, to my knowledge, I've never been barred from testifying.
And typically you testify for the defense?
Yes.
And you were testifying for the defense today?
That is correct.
And around these 250 testifications, this ends up to be around 75% of your income.
Well, the testifications and the legal work that happens before the court date, yes.
And 75% is the majority, correct?
Yes.
Majority of your income. So, as mentioned previously, it should have taken around 1 month for Ms. Patel to heal, correct?
That is correct.
And again, mentioned previously, she described a level 10 out of 10 pain.
When she was first presented to the ER, yes.
And she's also prescribed by Dr. Diaz 6 months of physical therapy?
Yes, but I don't see why that would be necessary with her injuries.
And do these symptoms indicate a severe injury?
The level 10 pain does not always indicate a severe injury.
Moving on, do any of these symptoms indicate a full recovery?
They do. None of these symptoms would rule out the possibility of a full recovery.
So is that a yes?
They do not rule out the possibility of a full recovery. It can still happen.
So it's a possibility, correct? Is that
Yeah,
what
you
you're
can
saying?
still fully recover, yes.
All right. So none of these indicate a full recovery, correct? Severe injuries.
The symptoms that she came to the ER with do not necessarily indicate a severe injury and do not prevent the possibility of a full recovery.
Ms. Patel scheduled a follow-up appointment, correct?
That is correct.
And Dr. Diaz told her to schedule a follow-up appointment if the pain continued.
Yes,
And the pain continued, correct?
that is correct.
And does that also indicate a full recovery?
Well, if it was due to symptom magnification, then yes, she could have had a full recovery. Or if she aggravated it in some way, then could have.
Thank you. Ms. Patel testified earlier that she cannot fully lift her arm above her shoulder or her arm above her head, correct?
That is correct, though I see no medical reason why she shouldn't be able to.
And does that indicate a full recovery either?
Again, I see no medical reason why she shouldn't be able to lift her arm above her shoulder.
No further questions, Your Honor.
All right, thank you. Any redirect, Ms. Favors?
Yes, Your Honor. Now, Dr. Strickland, opposing counsel mentioned your experience testifying in court for the defense. Now, does your past experience in any way affect the diagnosis for Jordan Patel?
Yes, in my experience, I've had years and years of experience dealing with the spine and the muscles surrounding the spine. So I would be most qualified to see if there was any physical damage to the spine and how that would affect you.
And does the side that you tested for, whether it's plaintiff or defense, does that in any way affect your medical diagnosis?
No, it does not.
Now, opposing counsel also asked you a significant number of questions regarding a full recovery for Jordan Patel. Now, can you explain how Jordan Patel, could they have a full recovery despite the claims they are making?
Oh, easily. I believe they've reached maximum medical improvement already, if not completely full recovery.
And why is that?
Well, simply because the injuries that she sustained that night were relatively minor. Any further injuries or complications would be the result of her aggravating the injury and not anything from that night.
No further questions, Your Honor.
All right, thank you. Ms. Baker, any recross?
Yes, Your Honor. So again, to go back to Miss Patel's symptoms, she had quite a few and she indicated a 10 out of 10 pain
Objection,
scale,
Your
correct?
Honor, outside the scope of my redirect.
All right, any response?
I'll move on, Your Honor.
All right, thank you.
Dr. Strickland, you typically testify for the defense, correct?
Usually, but not always.
And you've testified around 250 times,
At least, yeah.
typically for the defense.
Again, usually for the defense, but not always.
All right, no further questions, Your Honor.
All right, thank you. Thank you for your testimony. You may step down. And with the defendant, please call our next witness.
The defense rests, Your Honor.
All right, do we need a break here to set up for closing arguments?
Yes, Your Honor. The defense would request just 5 minutes recess to prepare for closing arguments.
All right, we'll be in recess for 2 minutes. You get 2 minutes.
Thank you, Your Honor.
All right, we're back on the record in the case of we have Patel, right? And are you all ready to go now?
Yes, Your Honor, the plaintiff is ready to proceed.
Okay, and the defendant?
The defense is ready, Your Honor.
Okay. So, members of the jury, you've now heard all the evidence in the case, and we will now hear closing arguments of the parties. They will each have 5 minutes to present their closing argument or statement. And on behalf of the plaintiff, we have Ms. Baker. Is that right?
Yes.
All right. You may proceed when you're ready.
Thank you, Your Honor.
And I understand you want to reserve any time that you have.
Yes.
Okay.
Actions have consequences. We all know this. We've learned it from a young age. Actions have consequences. Opposing counsel has, their whole theme has been actions have consequences, and that they are most likely pinning the blame on Miss Patel that her actions have caused this. But through our witness testimonies, Jordan Patel, Bobby Brennan, and Dr. Diaz, you have heard this with your own ears and seen it through the witness's eyes that Cameron Miller is liable. There are a couple of agreed facts throughout this case that the plaintiff and defense can agree upon and are apparent through the witness testimonies. Alcohol was served, and this alcohol was served at Cameron Miller's house and bought under Cameron Miller's name. Because of this, Cameron Miller had a duty to monitor this party, a duty to make sure everything went okay. but they did not uphold this duty. In fact, this party failed. The alcohol was continuously unmonitored, and we have proven that through our testimonies. There was free-flowing beer. Cameron Miller even themselves testified to the fact that we're filling up pictures of everyone else. And with this, the fact that this was on Cameron Miller's property, they assumed a duty and they breached it, and that this caused damage. This caused damage of Jordan Patel's physically, but not only physically, but their future and mentally. They will never be able to fully play volleyball again, as our witnesses have testified to. Their dreams of going pro and continuing to play volleyball and even win a championship are no longer reality because Cameron Miller breached this duty and did not uphold this duty, and they did not have this party responsibly. The alcohol was free-flowing, and this is what caused Jordan Patel to get hurt and their future to be changed forever.
All right, thank you. You will have 1 minute and 30 seconds left when you come back. And for the defendant?
Yes, Your Honor. May I proceed?
You may, Ms. Faber.
Thank you. Actions have consequences. This is not a case about alcohol, but this is a case about consequences. Now, actions have consequences is a phrase that we've all heard before. It's a phrase that we were taught when we were young, a phrase that repeats in our head in times of trouble. And it's a phrase that holds true in today's case. Now, there were consequences because of actions that occurred on May 2nd, 2020. And these were the actions of Jordan Patel, not Cameron Miller. Now, the plaintiff has filed a claim against Cameron Miller, claiming that they did not follow dram shop law, also known as Indiana Code 7.1-5-10-15.5. Now, the plaintiff had the burden of proof in this case. They had to prove to you by a preponderance of the evidence that first, the defendant had a duty under the law to not overserve a visibly intoxicated guest. They also had to prove that the defendant breached this duty. First, by having actual knowledge, it's very important, that a guest was visibly intoxicated. And secondly, by furnishing said alcohol to visibly intoxicated guests. Now, this breach of duty had to be the proximate cause of the injuries sustained by Jordan Patel. And they also had to prove that damages did occur. Duty, breach, causation, and damages. In order to meet their burden of proof, they had to prove by preponderance of the evidence, meaning more likely than not, that each one of these elements occurred. Now, if they did not meet just one element, they did not meet their burden of proof, and that is exactly what happened today. So let's walk through the evidence that the plaintiff brought before you. Now, the defense concedes that there was a duty under the law. They also concede that damages did occur, a fact that both expert witnesses agree on. But the plaintiff has not proved that Cameron Miller breached their duty. First of all, ladies and gentlemen, you've heard no testimony today that Cameron Miller had actual knowledge that the guest was first visibly intoxicated and secondly, overserved with alcohol. And furthermore, there is not enough alcohol logistically at that party to overserve a guest. Now, as you heard, Morgan DeLuca said, she told you today she purchased 2 half kegs of alcohol, 15.5 gallons each. Now that's 31 gallons. Dr. Diaz, the plaintiff witness, told us that a cup of alcohol is regarded as 12 ounces. Using that measurement, there were about 330 cups of alcohol at that party for about 150 to 200 people. That's 1.5 to 2 cups per person. That's not enough to overserve any guest. at that party. Now, the plaintiff has failed to prove breach, but they've also failed to prove causation. Now, as we learned today, and as we told you, actions have consequences, and Jordan Patel's own actions cause consequences on that day. First of all, when that incident at the party occurred, they had an offer of help multiple times, and they refused it. Jordan Patel sat there and told you when she was hurt, she didn't seek medical attention, she just walked away. She walked around that mini mansion and left that party. And she told you, she sat on that stand today and testified that she did not feel extreme sharp pain. She did not feel every muscle in her body constrict until she literally ran into Bobby Brennan after she left the party. Now that is not any sense of causation on Cameron Miller's part. Secondly, our expert witness, Dr. Strickland, took the stand today and explained all the major flaws in the plaintiff's case. Now, he told you that Jordan Patel had a right-sided disc bulge and left-sided pain. Now, his findings do not align with Jordan Patel's complaints of pain. The only explanation that he could give us? Symptom magnification. What does that mean? It means Jordan Patel is claiming there is pain that is not really there, claiming an injury that did not really happen. The plaintiff's case is based on guesses, on false claims, on assumptions. But at the end of the day, at the end of this trial, they have not proved breach and they have not proved causation. For this reason, they have not met their burden of proof by not proving every element. And for that reason, we ask you to find the defendant not liable, because actions have consequences. And Jordan Patel needs to be held responsible for her own actions, not at the sake of Cameron Miller.
Thank you, Ms. Favors. Ms. Baker, you have some time remaining if you'd like to use it.
Yes, Your Honor.
And I think I said before 1 minute and 30 seconds. It's actually 2 minutes and 30 seconds. So
Actions have consequences. Again, we all know this. But we are neglecting what opposing counsel is neglecting is Cameron's actions and their consequences. Jordan Patel is not the one that should or shouldn't be held liable. That is not why we are here today. We are here today to determine whether Cameron Miller is liable, not Jordan Patel. We have the burden of proof, as opposing counsel have said. We have to prove that Cameron Miller had a duty and that they breached this duty. Cameron Miller 100% breached this duty. They fully knew that Jordan Patel was drunk and they continued to serve alcohol. As in the testimonies today, you have all heard that Jordan Patel was in Cameron's room, jumping on their bed, and knocked into a pile of Legos. I'm not sure about you, ladies and gentlemen, but that does not seem like what a sober person would do. That seems like a drunk and intoxicated person. And even after this fact, Cameron even continued to stay in their room. Even though they told Jordan to get out, they still continued to stay in their room, and the kegs were free-flowing, no monitoring. And moving on to the actual altercation. Cameron saw Jordan bloody on the floor, and they did nothing to stop it. They had already breached their duty, and it was too late. They didn't even offer to help. Ladies and gentlemen, actions have consequences. We are not here today to prove Jordan Patel's actions, what they did or didn't do, and their consequences. We are here to prove Cameron's actions and Cameron's consequences. I hope you all today find Cameron Miller liable.